Sorry for the glitch.
Aman, just a second. Tech support, please. Can
Shall we start?
Yes, yes.
Okay. Good evening, everyone. I'm C. Aman Rajput, and I have a privilege for moderating this session. We welcome you all to this enlightful session organized by Committee on Commercial Laws, Corporate Economic Advisory, and NPO Cooperatives of ICAI on this occasion of World Labour Day. The committee has been working towards promoting legal awareness, economic advisory insights, and professional avenues for chartered accountants in domains such as labor law, industrial law, and economic policy making. Today's webinar is focused on compliances under labor law, that is, EPF and ESI Act. EPF means Employee Provident Fund and ESI means Employee State Insurance Act, an area that holds a significant relevance for practicing professionals, industry consultants, and employers, especially in the current regulatory environment that demand a strict adherence to employment-related legislation. It is an honor to welcome our speaker for this evening, CA Avinash sir. He holds a fellow member of Institute of Chartered Accountants of India and has been practicing since 2011. He holds post-qualification certifications in indirect taxation and advanced ICA Level 1 in 2024. With vast experience in indirect taxes and labor laws, he has been actively advising reputed firms, corporates, and public sector undertakings in Chhattisgarh and beyond. We are confident that today's session will equip our members with knowledge and clarity to better advise their clients and employers on labor law compliance. Without further delay, I would now invite CA Avinash Toteja sir to commence today's session on labor law compliances under EPF and ESI Act. We welcome you, sir.
Thank you so much, Aman. At the outset, a very warm evening to everyone present over here and to all our listeners of this webinar. Yesterday only we celebrated the Labor Day, which is the 1st of May every year. And today here we are going to have as a webinar on a very important topic of compliances, which requires each and every business house to take care of in the field of EPF and ESIC. These are the two laws which constitute of paramount importance that every business house, every organizations should take care of, so that the laborers working over there gets what is required and what is to be done to safeguard both the employer as well as the employee's interest. At the outset, first of all, I will take up the matter of EPF and MP Act 1952. To begin with, let us see when the EPF Act becomes applicable on any factory or premises or any establishment. So every establishment or a factory which employs 20 or more labor or employees, then the Act becomes applicable on that particular establishment. Now, this 20 employees strength that needs to be seen when it becomes applicable, it may be on any given day in a year. So if any given day in a year, the employee strength touches the threshold limit of 20 or more, then the EPF Act becomes applicable on that particular establishment. And it becomes the duty of that establishment to get itself registered under the EPF Act and make all the compliances which are required to be done under the EPF Act. Now, when we talk about the term establishment, then the term establishment includes all the departments, all the branches, and all the workplaces that combine the establishment as a whole. So let us take an example. If there is a company which have a registered office in Delhi, and in Delhi, there are 5 employees working over in the head office. And the company has 4 branches across India. And in each of the branches, there are 5 employees. So in total, the employee strength becomes 25. So when we see when an establishment have to register itself under EPF Act or not, then we have to see the establishment as a whole. That means all the branches, all the depots, all the warehouses, everything which is a part of a business of the establishment that needs to be seen, and all those workplaces will be covered to see the employee strength. In this case, I have to take a special provision here over here that when we talk about any cooperative society, the normal strength to get itself registered, as we just discussed, is a 20 for any establishment. But when we talk about any cooperative society, that means any cooperative society which is registered under the Cooperative Society Act 1912 or any other law for the time being made in force. In that case, the EPF Act becomes applicable only when it reaches 50 employees, that is 50, and it is working without the aid of power. Then only the EPF Act will become applicable on that particular cooperative society. So if any cooperative society is working with less than 50 employees and it is working without the aid of power, then the corporate EPF Act will not become applicable on that particular establishment, which is in the form of a cooperative society. Next, when you talk about any cinema hall, in that case, the employee strength has been reduced to 5. That is to say, if there is any cinema hall which is working with 5 employees or more, then the EPF Act becomes applicable on that particular establishment. So there are provisions which are divergent from the main provision. The main provision says the employees' strength has to reach 20 employees, then the EPF Act will become applicable. But in the case of a cooperative society and in the case of a cinema hall, there are two different provisions. The cooperative society without working the aid of power, then the EPF will become applicable when it has 50 employees or more. And for cinema hall, the limit from 20 has been reduced to 5. So if there's any cinema hall working with 5 employees, then the EPF Act will become applicable on that particular cinema hall. Now, when we talk about this concept of 20 employees, then there is a section 1.3 which says if you reaches the strength of 20 employees, then the EPF will mandatorily become applicable on the establishment. But what about if there is any establishment which wants to get itself voluntarily involved or enrolled in the EPF? Then there is a section 1.4 of the EPF Act which says that if any establishment and majority of its employees are of the view that they want to get the benefit of EPF and the employer also want to extend the benefit of EPF to its employees, then they get enrolled even if the employee strength does not reaches the threshold limit of 20 employees. Let's say, for example, there is an establishment in which there are only 12 employees are working, and all the employees or the majority of the employees are of the view, and also the employer of the view, that the EPF should be or establishment should be get covered under the EPF Act. Then in that case, an agreement need to be signed between the employer and the employee, which says that the employees are willing and the employers also willing to provide the benefit of EPF to its employees. Then on the basis of that, a notification will be published or the application needs to be made to the Commissioner of Provident Fund, and after that a notification will be published in the official gazette, and that particular establishment will get itself enrolled under the EPF Act, and it has to make all the compliances which are related to the EPF. So EPF has two sections. One is a mandatory coverage. That means when there is a 20 employees in any establishment, then the EPF will get automatically activated, or you can say that will become mandatorily enrolled in the EPF, and the employee strength is less than 20, then also the establishment can get itself registered under the EPF Act. So this is the thing, or this is the one limb of the applicability of the EPF Act on any particular establishment. Now, like I said, the EPF Act says if you cross the limit of 20 employees, so the word employee is of paramount importance in the EPF Act. Who is an employee? When we say EPF will become on ability of 20 employees, then who is called as an employee in the EPF Act? So any person who is employed for wages and in any kind of work, whether it is manual or it is otherwise, or which is in or in connection with the work of an establishment, and also who gets his wages, that is the salary you can say or wages you can say, from the employer, he will become an employee for the establishment for the purpose of EPF Act. Now, this is the one limb of the Act which says about the employee, that any person who is getting wages, who is employed for the wages, and the wages that he may be getting directly or indirectly from the employer. And the work that is involved, it may be either mechanical, it may either be manual, or it can be anything. If he is working for an establishment, he will covered within the definition of employee. Plus, if any employee is engaged through a contractor, if any employee is engaged through a contractor in an establishment in connection with the work of the establishment, even that particular employee or even that particular person will be called as an employee of the establishment itself. Let us take it this way. Let's say, for example, if there is an establishment which has 12 employees of its own, plus one of the business processes has been outsourced to a labor agency who engages 10 employees in a particular establishment. Now, in this particular establishment, the employees are now of two categories. One, who are directly on the payroll of the company, there are 12, plus there is 10 employees who are working through a contractor or who are engaged by a contractor to whom a work has been outsourced by the company. In total, there are 22 persons working in that particular establishment. So in this case, the EPF Act will become operative or will become applicable on this particular establishment. Because when we talk about the employee word in the EPF Act or definition of employee in the EPF Act, it not only includes the direct employee who are on the payroll of the company or the establishment, but it also includes the employee who are working through a contractor and which is in connection with the work of the establishment. So in this case, the employee strength, the example that I took, will be 22 for the purpose of counting the employee strength of any establishment. Next, if there is any apprentice which is engaged in the establishment, then he will also be included within the definition of employee as per the EPF Act. But if an apprentice is engaged under the Apprentice Act 1961, then he will not be counted in the employee strength of 20, or the you can say he will not counted as an employee of that particular establishment. So if there is an establishment where there are 16 employees who are working or on the payroll of the company, plus there are 5 apprentices who are working in the company, and they are the apprentices who are covered or are engaged as per the Apprentice Act 1961, then the overall strength may be 21 of the establishment, but the EPF Act will not become compulsorily applicable on that particular establishment. Reason being, the 5 persons who are working as an apprentice are not included in the definition, or not, you can say, put in the definition of employee as per the EPF Act. Now, this is we called what is the employee who is termed as an EPF Act. There's also a concept of an excluded employee in the EPF Act. Now, an excluded employee means if there is an employee who is drawing a salary of 15,000 or more per month, an employee who is drawing a salary of 15,000 or more per month, then he is called as an excluded employee in the EPF Act. And also apprentice that we just discussed. But when we talk about the employee strength of 20 for the purpose of application of EPF Act, then both the coverable employees and the excluded employees in this particular case has to be counted for the purpose of seeing whether the EPF Act will become applicable or not. Take an example, if there is an establishment where 15 employees are working whose salary is less than 15,000 per month, plus there are 7 employees who are working whose salary is more than 15,000. Let's say example, it is 22,000. So in that particular case, there are 15 employees plus 7 employees. It becomes a collective ratio of 22 employees. So the EPF Act in this situation will become applicable on this particular establishment. Reason being, because when we when we talk about the employee strength for the purpose of application of EPF Act, then it says the employee has to be there. So if whether he is an excluded employee or whether he is a coverable employee under the EPF Act, it does not make any difference. Although in those 22 employees, it does not mean that you have to make a contribution or you have to make you can say compliances in respect of those 22 employees. Only those employees which are coverable, in respect of those employees only, the establishment needs to make the compliances. To put it in a simple way, in the example that I took, there are 22 employees, 15 employees are having a salary of, let's say, for example, 13,000, and 7 employees are having a salary of 22,000. So in this situation, the establishment or you can say the company needs to make compliances or to pay the EPF of only the 15 employees whose salary is less than 15,000. In respect of those 7 employees, the company need not to make any contribution. I guess this thing is clear up to here. Now, there is only another special provision for the newspaper establishments. The provision that we just discussed here, that an employee who at the time, you can say, is having a salary of 15,000 or more will be called as an excluded employee for a newspaper for any normal establishment. But that is not the case for a newspaper establishment. To put it this way, if there is a newspaper establishment, coming to that example back, where we have 22 employees working in an establishment, and let us say that establishment is a newspaper establishment. So in this situation, 15 employees who are drawing a salary of less than 15,000, 13,000, let me say, in that particular case, the EPF needs to be paid by the company. What about the 7 employees who are drawing a salary of 22,000? See, in this particular case, the company needs to make, the newspaper establishment needs to make contribution or the compliances or pay the EPF in respect of all the 22 establishment or all the 22 employees. Reason being, when we talk about the excluded employees where the 15,000 cap has been given for a normal organization or a normal, you can say, establishment, this benefit has not been extended to a newspaper establishment. The newspaper establishment has to mandatorily make contribution in respect of each and every employee if it reaches the threshold limit of 20 employees. So it may be possible that newspaper establishment may be having employees who are earning a salary of 25,000, 30,000, but those excluded employees, which are, you can say, are called as excluded employees for a normal organization, the company for whom the contribution may not to be paid by any normal organization, but in case of a newspaper establishment, the contribution has to be paid in respect of all the employees, irrespective of their salary. So this was a special provision for a newspaper establishment. Now, coming to the topic, how much is the contribution that needs to be paid by the company and how much is the contribution that needs to be paid by the employees. So in EPF Act, the total contribution that has to be paid by the company is 24%. This 24% has a bifurcation. The bifurcation is like that. 12% the company has to pay out of its own pocket, and 12% it needs to deduct from the salary earned by the employee every month. And this 24% has to be deposited by the company or the organization or the establishment to the EPF account of that particular employee. Now, when we talk about this 12%, so this becomes very important to know how this 12% is to be calculated on what wages. So the Act says the 12% as the contribution that needs to be paid of 12% either by the employer or by the employer, 12% that we are talking about. It is of the basic wages plus dearness allowance and retaining allowance. So these three things will be covered under the wages, or the, you can say, the component of the wages of any employee on which the EPF has to be paid. So the contribution of 12% is to be calculated of basic wages, dearness allowance, and retaining allowance as a cumulative. Now, let us come to this. There is an explanation which has been given, which says that for the purpose of this section, or the purpose of calculating the dearness allowance, shall be deemed to include also the cash value of any food concession allowed to the employee. So if there is any food allowance, you can say, which are given to an employee, or the concession in the canteens are allowed to an employee, that will also be included in the dearness allowance of the employee, and EPF contribution has to be paid mandatorily on that particular case. Like I discussed earlier, now the next question which comes to mind is the 12% contribution which is payable is of the entire salary or of the entire basic wages and dearness allowance, or there is a capping limit on which the maximum contribution will be fixed, or will be capped according to the law. The wage ceiling limit under the EPF Act is 15,000 per month. That is to say that if an employee is earning a salary of, let's say, for example, 20,000, and the company only has basic wages and dearness allowance. These are the only two components which the company has in their organization. So the question becomes here that whether this 12% has to be calculated 20,000, or there is a capping limit. There is a capping limit, that is the 15,000. That means the 12% has to be calculated of 15,000 of basic wages and dearness allowance. Over and above that, the company is not required to make the contribution of salary which is over and above the 15,000. Now, there comes a question whether in the previous slide we just discussed that there is an employee who is earning a salary of more than 15,000, then he is called an excluded employee of an establishment. And here I'm saying that if he's getting a salary of 20,000, the EPF needs to be paid in the case of the employee. So let me clear this topic once again. See, in EPF Act, there is a concept that if an employee becomes a member of the EPF, then if he is in the employment or he is in the company which is enrolled under, which is covered under EPF, then irrespective his salary increases beyond 15,000, he will continue to be the member of the EPF Act. That means once applicable, always applicable. So if a member becomes, if an employee becomes a member of EPF, or he gets enrolled in the EPF, then he will continue to be the part of the EPF that we call member. In technical terms, they are called as member of EPF. He will remain as a member of EPF till he's in the company which is registered under the EPF. Let us put this in this case of an example. Let's say Mr. A joined an establishment on 1st 4/24 with a salary of, let's say, for example, 12,000. And again, to put it in a simple way, let us say this was the basic plus dearness allowance. These are the only two components which are present over this particular company. Now, after 1 year, that is on 1/4/25, the company enhanced his salary or increased his salary, and he is now getting a salary of, let's say, for example, 18,000. So in this particular situation, on 1/4/24, when Mr. A joined that particular establishment and EPF was applicable on that particular establishment, then in fact situation, the company enrolled or Mr. A in the EPF and he became a member of EPF. Now, after 1 year, when he got a hike in the salary and the salary from 12,000 increased to 18,000 per month. So in that particular situation, his salary is now more than 15,000 per month. That means there may be an argument that he may be now come under the category of excluded employee. But that is not the situation. The EPF Act is very clear about this. It says if a particular employee becomes a member of EPF for once, then he will always remain a member of the EPF, irrespective of his salary, whatever increase there may be. But in this situation, the question arises whether the 12% needs to be calculated on entire 18,000. I'm assuming there's only two components. Keeping that in mind, there are only two components present in the salary structure: basic allowance plus basic and dearness allowance. So, considering this, if the salary has increased to 18,000 per month, so whether this point is clear now that he will continue to become, he'll continue to be the member of the EPF, and the contribution needs to be paid in that particular, in the case of this employee, because the salary has crossed the threshold limit of 15,000, because once a member, always a member. The concept is clear. Now, when we talk about what needs to be done in this case, whether the 12% has to be paid of entire 18,000, that is basic plus DA, or there is a capping. So there is a capping which says that 12% need not to be paid on the entire 18,000 if it has crossed the threshold limit of 15,000. It has to be capped, it has to be restricted to 15,000. So in this case, the 12% of contribution that Mr. A will be paying or will be contributing, and 12% which the company will be bearing on behalf of Mr. A as a is EPF share will only be restricted to 15,000. That is 1,800 on the part of the company and 1,800 on the part of the employee. Now, again, coming to this topic, I will just take you back to the applicability once again. When I said if in any establishment 20 employees are there, then the company becomes, you can say, it comes under the mandation of get itself enrolled under the EPF Act. Let's say, for example, if once the threshold limit of 20 employees is reached, or you can say crossed by any company, and subsequently after 4 months, the employee strength comes down to below 20. So whether the EPF Act will continue or it will stop to continue, or the company will come out of the ambit of the EPF Act. The situation is not like that. Once an act becomes applicable on an establishment, that establishment will continue to be governed by the EPF Act. So let's say, for example, in April 24, the employee strength of a company was increased from, let's say, for example, from base of March 24, from 18 to 25. So the EPF Act became applicable in April. The employee strength of 25 continued for, let's say, for example, next 3 months till July. And in August 24, the employee strength came down to 12. So in this particular situation, since the employee strength has fallen below 20 employees, but still the EPF Act will continue on, or EPF Act, the particular establishment will be governed by the EPF Act, and it has to make compliances in respect of the employees which are present in its payroll. Now, coming to this topic of that we were discussing of the employee who are getting a salary of more than 15,000. So we just discussed one of the conditions, that if an employee is once covered under the EPF Act, once he becomes a member of EPF Act, then he will continue to be the member of the EPF Act. Once a member, always a member. So let's take an example like this. Mr. A joined a company and he was never enrolled in the EPF Act before. So before jumping to the topic, I will conclude the topic of which we were discussing of 15,000 once again. Let's say, for example, Mr. A, who was getting a salary of 12,000 per month, and he became a member of EPF in April 24, and subsequently, his salary increased to 18,000 in April 25. Then, like I said, he will continue to be governed by EPF Act. Contribution needs to be paid by him and also by the company of 12% each, although the capping may be on the 15,000 of salary. Let's say, for example, in June 25, Mr. A switched the company and he left his old company and joined a new company, which was also enrolled under the EPF Act. And he joined on a salary of, let's say, example, 25,000. Now the question arises whether he still has to pay EPF or whether the company still has to pay EPF in this case. The answer is yes. Because if you join a company which is enrolled under EPF and you are also a member of EPF, then in respect of the salary, the contribution has to be paid. In your case, whether you are continuing the same company or whether you are switching the company or you get transferred to any other company or you resign from a company and join any other company. That does not make a difference. The contribution still needs to be paid. But yes, the contribution has to be on the salary of 15,000 only. Now, let us take an example that Mr. A is joining a company on 1/4/24 and this was his first employment. He was never in employment in any company before. His fresh employment, he's a fresh candidate, and he has been, you can say, getting a salary of 20,000. Again, I'm assuming this salary of 20,000, this salary structure has only two components, basic and dearness allowance. 20,000 basic plus dearness allowance. And Mr. A was never an employee before any of the company. Neither he was a member of EPF. So whether if he wants to join the EPF, whether he can do so. That means if an employee voluntarily wants to become a member of EPF, he's in a company where EPF is applicable. The company is providing EPF on all the employees that are over there. And there is a fresh candidate which has joined the company and he has a salary which is beyond the statutory limit of 15,000. And the employee was never a member of EPF earlier. So whether he can become, that means a member can voluntarily become a member of EPF. In this case, the answer is yes, he can become a member of EPF. And as per the para 26 clause 6 of a EPF scheme, it provides an option to the member that if he wants to become a member, then on the basis of joint declaration that needs to be submitted by the employer and the employee, he will become the member of EPF. And the benefits of EPF will be extended to him. But again, there is a capping of 15,000. If ANF is joining a salary of 20,000, he was never a member of EPF earlier, and he wants to become a member of EPF, and the company where he is joining also wants to extend him the benefit of EPF, then there is a possibility. Then he can become a member of EPF voluntarily, but the contribution has to be on 15,000 of salary, not more than that. Now the question is whether the excess contribution can be made, because overall I'm discussing here, there is a statutory limit of 15,000 of EPF. The question is whether this statutory limit can be exceeded or the excess contribution can be made of the salary which is more than 15,000. The answer is yes. The answer is an affirmative. If an employee wants to make a higher contribution, if he wants, let's say for example, Mr. A, whose salary is 20,000 and he is covered under EPF, he is a member of EPF. If he wants, he can make a contribution entire 20,000, that is the 12% that the employee share that he will get deducted from the employer will be of 20,000. But the employer is under no obligation to match that contribution. That is to say, the employer will continue to pay 12% of 15,000, that is the cap limit, If he wants to, if the employer wants to contribute more, he wants to provide some extra benefit or some, you can say, extra, you can say, contribution on the behalf of employee, then he can do so. But there is no obligation whatsoever on the employer that he has to match the contribution of the employee if the employee is contributing more than the salary of 15,000. So there may be a situation where a minister is earning a salary of 20,000 and he may be contributing 12% of 20,000 as his share. That means of, you can say, the deduction has to be of 20,000 in this particular case from the salary of Mr. A. But the employer will continue to make a contribution on 15,000 of salary only. The matching concept is not there, or you can say there's no obligation, like I said earlier, on the part of the employer to match the contribution which is made by the employer. This is only in the case where the salary is exceeding 15,000. If the salary is less than 15,000, there has to be a 12% of the salary earned. That topic I'm discussing here, or you can say the point I'm discussing here, is in the case where there's only the salary where it exceeds 15,000. In that particular case only, the employee can make a higher contribution if he wants to. But that is not the obligation on the part of the employer. Now, we have learned so far who is an employee of the company, whom we call it as an employee of the company. Next, we have learned how much is the contribution of either the employer and the employee. This thing has been covered. We have also covered there is a capping limit of 15,000 on which the contribution needs to be made. And how, if an employee wants, whether he can make a higher contribution, then yes, there is a possibility. Now, like in every other act, there is also a due date which has been prescribed under the EPF Act, up to which this contribution has to be paid on the behalf of the employee to the EPF account of that particular employee. And the due date is the 15th of the next month in which the wages fall due. Let's say, for example, for the wage period of April, the due date for payment of EPF, or the due date of payment of contribution of the employer-employee, is 15th of May. For the month of May, it will be 15th of June. For the month of June, it will be the 15th of July. So 15th of the next month in which the wages fall due, or whether we can say the wage period, the contribution has to be paid by the 15th of the next month. That means by the 15th of May of the 15th May 2025, the contribution of April 25, that is the EPF contribution of April 25, the company has to pay till 15th of May. When you call a contribution, that is the 12% that it will deduct from the salary of the employee, and also the 12% that it has to pay out of its own pocket. Now, this is one of the things. Now, apart from this 12% contribution that the employer has to pay out of his pocket of you can say, his share of contribution as to the EPF account of the employee, the employer has to pay 1 more percent. And this 1% is basically divided into two components. One is an EDI charges. I'll come to it, what is EDI charges. And one is admin charges. This 1% is split into 0.5, 0.5. 0.5 is the EDI charge, that is the employee deposit link insurance. It is just like the lifetime insurance, which is provided to the member of EPF, that is the employee. And in the case, unfortunately, in the case of demise of the employee, this life insurance or this amount of life insurance will be paid to the nominee of the member. There is a capping of 7 lakh rupees, the maximum insurance amount that will be paid. For this insurance, the 0.5% charges will be recovered or will have to be borne by the employer. Also, 0.5% as an admin charges has to be borne by the employer. This 0.5% that I'm talking about the admin charges. There is a two comparative amount for that. It is either 0.5% of the salary or 500 rupees per month, whichever is higher. So let's say, for example, if in any particular month the contribution for the EPF is, or you can say the salary for any particular month is that on which the EPF has to be paid. When I'm talking about the salary, I'm talking about the collective salary. Let's say, for example, in a company there are 8 employees and EPF is applicable on that particular establishment, and each one is getting a salary of 10,000. And let's say, for example, in the month of April, the total salary that is paid to the employees is 80,000. So if I take 0.5% of the 80,000, so it will be only 400 rupees. But in this case, the administration charges has to be paid is 500 rupees. So the minimum administration charge or admin charges that has to be paid is 500. It is either 500 or 0.5% of the salary, whichever is higher. And this is purely for, you can say, the running of the administration of the EPF, or you can say of that administration of the EPF fund. This is neither paid to the employee, this is neither paid to the nominee of employee, and nothing like that. The 24% that I was telling, obviously it goes to the EPF account of the employee, and if he can either withdraw or take an advance against it, that is a separate, you can say, matter to deal with altogether. We are talking here about how much the employer has to be paid. So the contribution of 12% of employer, contribution of 12% of the employee, it is a responsibility of the employee to deduct EPF from the salary of employee. It is the you can say the obligation which has been casted by the EPF Act on the employer that he has to deduct employee's share of EPF from his salary, add his share, add employee's share, that is 12%, and pay to the EPF account of the employee via a challan. And like I said, there is additional amount that needs to be borne by the employer, 0.5% EDLI charges and 0.5% administration charges. Let's say, for example, if there is a delay in payment of EPF, so what are its repercussions or what are its consequences? Like in any other act, there is a provision of interest and there is a provision of penalty, which is called damages. Section 7Q of the EPF Act says, if there is a delay of payment beyond the due date of 15th of the next month, then the employer has to pay a simple interest at the rate of 12% per annum. So this will be counted on a day basis. So if the contribution of April 2025 is not deposited by the employer till the 15th of May 2025, and the employer deposited that, let's say, for example, on 28th May. So he has to pay an interest of for 5 days at the rate of 12% per annum, simple interest. And this is one penal consequences. Another is the damages that I was talking about, the penalty that I was talking about. The damages amount is restricted, or you can say it depends upon the period of default. So if the default is from 0 to 2 months, or there is a delay of 0 to 2 months in the payment of EPF for any particular wage period, then it will be 5% per annum. If it is 2 to 4 months, more than 2 months and up to 4 months, then the amount of damages will, or you can say the percentage of damages will increase to 10% per annum. If the delay is more than 4 months and up to 6 months, then this rate will increase to 15% per annum. That is the rate of penalty or the damages that needs to be paid for the delay filing or delay payment of EPF contribution. Next, if the delay is more than 6 months, then the penalty that will be imposed on the employer will be 25% per annum. So let us say if a company has not paid its dues for 5 years, or you can say if it has not paid its dues of 2018. So whether the damages at the rate of 25% per annum, it will become multiple folds, it will even cross the basic amount of contribution. So the EPF Act says the amount of damages, that is the penalty that I'm talking about, it will not go beyond the amount of the contribution that the employee has, the employer has failed to pay to the EPF account of the employee. So there's a capping of the damages or the penalty that we say in the common language on the damages amount that has to be paid for delay in filing, and it is maximum up to the amount of you can say contribution. It cannot exceed the basic amount of contribution, but there is no such capping on the interest. Interest, if there is a delay of 7 months or you can say 7 years, the interest has to be paid for 7 years, even if it crosses the basic. If it is for the 10 years, even if it crosses the basic amount of contribution, then the entire 12% will be calculated. That means the amount of interest for delay in payment can exceed the amount of contribution, but the amount of penalty for delay payment cannot exceed the amount of basic contribution. So one reason that I find the reason why this is because if you are paying a contribution which was due, let's say for example, in April 20, and in April 25, or you can say March 25, that contribution is paid. So there is a gap of 5 to 6 years. In this particular situation, the employee whose contribution was due in April 20, which has been paid by the employer in March 25, that the employee will get an interest on that particular contribution from April 20 till the date of this one, March 25. He will continue to get the interest. He will get the interest from that particular date in which the contribution was originally due, not when the payment is made by the employer. The interest account or the EPF interest will be given, or the interest on the EPF balance will be given from that particular original due month, and not when the actual, you can say, the contribution is paid by the employer. That is why this interest and damages are recovered from the, apart from, you can say, punishing for, you can say, the violation of the law. One of the reasons that the interest is recovered from the employer is because the EPF department has to pay interest from the original date, or the, you can say, wage month for which the contribution is paid. Now, coming to this topic, like I said, the 12% contribution is on the part of the employer, and there's a 12% contribution on the part of the employee. Now, this 12% which is deposited to the EPF department on the behalf, or you can say EPF account of the employee, is divided into two parts. First of all, I'm talking about the employees who are below the age of 58 years. In case of those employees, the employee contribution of 12% goes entirely to the EPF fund, Employee Provident Fund. And the 12% which a employer is contributing in case of an employee who is below the age of 58 years, that is split into two parts. 8.33 goes to EPS fund, that is the pension fund, and 3.67 goes to the EPF fund. So in case of a employee who is less than 58 years of age, his, you can say, the contribution or the 24% is split into two ways. Employee contribution entirely to the EPF fund, employer contribution two ways, split into two half, or you can not half, but two, you can say, parts. 3.67 to the provident fund, and 8.33 to the pension. Now, let us take a look at the employee who is more than 58 years of age, who is 58 years and above. Then his membership of the pension fund, that is the EPS, will cease to exist. No, he cannot no more become, or you can remain the member of the EPS. That is, in his case, the 12% of the employer also will go entirely to the pension fund. That means till the age of 57 years and you can say 11 months, till he attains 58 years, the contribution made by the employer on behalf of employee will be split into two parts: 3.67 to the provident fund and 8.33 to the pension fund. From when he attains 50 years of age, from that wage month till he retires, he will, his contribution will, obviously the employee contribution in either case, whether he is of 58 years or not, it does not get bifurcated. It goes entirely to the provident fund. But the employer contribution of any member, or you can say any employee who's more than 58 years of age, goes entirely to the provident fund. Even if till he was below 58 years of age, his contribution was split into two ways. Now, there's an important note in this case, which I want to bring to the knowledge of all of you. Let's say, for example, if an employee joins an establishment after 1st September 2014, I'm talking about 11 years back, and his salary, his wages, that is the EPF wages that I'm talking about. That means his salary is more than 15,000. That I'm talking basic plus DA. I'm assuming that whatever his salary is more than 15,000. And both the employer and employee the employee also wanted that I want to become a member of EPF. Employer also said, okay, I will provide the extend the benefit of EPF or provident fund to this particular employee. And he was hired on a salary of, let's say, for example, 25,000 or 30,000. So if he was hired on a salary of 30,000 after 1st September 2014, and assuming he's a fresh employee, that means he was not an employee anywhere before where the EPF Act was applicable. So in this particular situation, he cannot become a member of a pension fund. That means in this situation also, his entire contribution will go to the provident fund only. So let us take an example. Mr. A joined establishment on 1st April 2024, and he was recruited for a salary of 30,000 per month. And the salary structure again included only two things: 20 basic plus DA and nothing else. In this situation, his salary is, you can say, more than 15,000. Basic plus DA is more than 15,000. So in this situation, and he's less than 58 years of age, keeping this in mind, the entire employer contribution will also go to the provident fund, not to the pension fund. So 12% employee contribution will also go to the provident fund, and 12% employer contribution will also go to the provident fund. But let's say, for example, the basic plus DA salary, that is the EPF salary, we say, is less than 15,000. Mr. A joined on 1st April 2024, and he was earning a salary of 12,000. In that case, he will become a member of pension fund. That means his salary is the contribution of employer in this particular case will be split into two parts again: 3.67 to the provident fund, and 8.33 to the pension fund. Now, why knowing this is important? Because at the time of withdrawal, there has been numerous cases which has come to us where we see that the companies have made a mistake and made such members, or you can say such employees, who are hired on a higher salary, that's a 30,000 of a basic plus DA, and their employment started after 1st September 2020, or you can say 2014, and that particular employee was never a member of EPS before that, and the company has paid the salary, or you can say paid the contribution of the company in the pension fund. That means the amount which was not to be deposited in the pension fund was deposited in the pension fund. The numerous cases has come forward to us in this particular, you can say, scenario. In this case, what needs to be done is there is a form 3A, revised form 3, that the employer need to submit to the concerned regional EPF office, and the concerned EPF regional office will transfer the fund from the pension fund, which was not to be a part of the pension fund of the employee, to the provident fund. And in this particular case, the employee can withdraw if, as and when he becomes eligible, to withdraw or take an advance against the particular, you can say, EPF account. Otherwise, the claim for the EPF gets rejected. Now, when I was talking about, you can say, the term 12%, as we just discussed right now, the term basic wages, which has been defined in the EPF Act, it says, because the entire contribution, as we just discussed, the EPF Act is paid on basic wages plus dearness allowance and retaining allowance. The basic wages means what the basic wages has been defined in EPF Act. I'm just reading it out. All the emoluments which are earned by an employee while on duty or on leave or on holidays with wages, that is the leave with pay we are talking about, in either case in accordance with the terms of the contract of employment, and which are paid or payable in cash to him, but does not include, you can say, what you're saying, house rent allowance, overtime allowance, bonus, commission, or any other similar allowance which are payable to the employee in respect of his employment or on the work done in such employment, or any presents which are made to the or made by the employer. So, as you can see, what this definition wants to bring out here is that when we talk about basic wages, it is trying to exclude all type of allowances which are paid to the employee. All the allowances which are paid to the employee has been excluded. Maybe HRA it is saying overtime allowances, bonus, commission, or any other similar allowance which are saying. So, for example, there is a children allowance, there is an education allowance, and plus children education allowance, hostel allowance. There is a, you can say, city compensatory allowance that we all know, and there is a, you can say, conveyance allowance or traveling allowance. So this all has been excluded from the definition of basic wages. Now, this thing was very much appreciable, and this thing was very much the, you can say, the law till 28th February 2019. On 20th February 2019, Honorable Supreme Court has given a landmark judgment in the case of Regional Provident Fund Commissioner West Bengal versus Vivekanand Vidya Mandir, and it outlined, you can say, the method of whether considering any allowances as a part of basic wages or not. And you can say this is a very, you can say, a thing which has caused the companies to make the, you can say, contingent liabilities for the PF that has to be paid for the back period also, because this is in the form of an explanation, or you can say it has just clarified what the definition of basic wages has meant. That means it was always there in the act, The definition, the meaning of basic wages is always there in the act, but the people were not following it, or the companies were not following it. What it said, the Honorable Supreme Court said that, I'm just reading out, the Honorable Supreme Court ruled out that to be excluded from the definition of basic wages, if we want to exclude any allowance from the definition of basic wages, and on which the EPF contribution need not to be paid, there has to be few tests which has been laid down. First is the allowances are variable in nature. That means if we want to exclude any allowance from the definition of basic wages, if an allowance is excluded from the definition of basic wages, but automatically no EPF will be required to be paid on that particular allowance, or it will not be a part of the, you can say, amount which is subject to EPF. First is allowances are variable in nature. This is the first thing. Next thing is allowances which are linked to any incentive for production resulting in greater output by an employee. That means it has to be linked with some kind of a activity which leads to the greater output, or you can say greater production from that particular employee. Next, allowances which are not paid across the board to all the employees in a particular category. I'm telling the conditions, or you can say the test which has been laid down by the Supreme Court to exclude any allowance from the definition of basic wages. It is saying allowances which are not paid across the board to all employees in a particular category. And lastly, it is saying allowances which are paid especially to those who avail the opportunity. I'm just telling you what is the crux it means. It is saying if a allowance is paid uniformly, unilaterally to all the employees of the company, then such allowance cannot be excluded from the definition of basic wages. It will become a part of our basic wages, and EPF contribution need to be paid on that basic wages, on that particular allowance. Because what the companies were doing, the companies were splitting for the purpose, you can say, their entire salary structure or even the basic wages to become a part of the other allowance on which the EPF is not payable, just to forgo, or just to, you can say, get away from the contribution of EPF and on the salary portion, and just to, you can, which will have the impact on the salaries, or which will have the impact on the EPF contribution of the employer and employee. So to cover all those things, the Supreme Court, what it said is that all the allowances, if any allowance is paid uniformly, if it is paid, you can say, across the board to all the employees, then that allowance has to be mandatory part of your basic wages, and EPF contribution definitely becomes due on that particular. For any allowance to be excluded from the definition of basic wages, it has to be a special allowance, and there has to be circumstances which warrant the need to pay that special allowance. Simply by changing the nomenclature of any allowance, it does not become an allowance which is special in nature. That is why it is said, the Supreme Court has said, to exclude any you can say, allowances has to be variable in nature. It has to be linked with any incentive or production. It has to be the thing which is not paid across the board to all the employees in a particular category. And there is allowance which require or which are paid especially to who those avail the opportunity. Otherwise, if that is not the situation, then the allowances have to be included and EPF contribution has to be paid on it. Now, this is a very, you can say, landmark judgment, and the department Even a review petition was filed against this particular Honorable Supreme Court ruling, but it also get rejected for the want of, you can say, any justifiable evidence which could be produced, which can overturn this decision. So at present, you can say, as we know, the ruling of any Supreme Court is the law of the land. So this is the situation. And now coming to the point of this thing, what the companies were doing earlier, that they were sabotaging, or you can say they were reducing their contribution of EPF by splitting their basic budget into allowances, which were not the actual allowances. So it has now, this practice has now to be done away with, and we need to examine whether to call any allowance special allowance. We have to see that it is really paid in a special circumstances, and it is not uniformly and unilaterally paid to all the employees. Now, one of the things that I was discussing earlier, if you remember, when we were talking about the employee strength of any establishment, which needs to be included for the purpose of seeing the threshold limit of 20 employees in any factory or any, you can say, organization, they were discussed that not only the direct employees, or you can say the employees which are on the payroll of the company or the establishment, are to be included, but also the employees which are hired through the contractors also become a part of the employee strength of 20 to see the application or to see the applicability of EPF Act. Now the situation here arises is the employees which are hired through the contractors. Let's say, for example, there is a company who is having 12 employees of its own, and also there are 10 employees which have been hired through a contractor, and the strength has gone beyond 20, 22, you can say the threshold limit of 20, there are 22 employees. In this situation, it becomes compulsory for this company to obtain an EPF registration and to pay EPF dues in the case of employees not only on its payroll, but also in the case of the employees which have been hired to the contractors. Now the situation arises, the company will be called as a principal employer, and the contractor to whom you can say the employees have been hired for a work in the establishment is going to be called as an immediate employer. The EPF Act empowers the principal employer that whatever contribution the principal employer is paying on behalf of the immediate employer, that is, whatever the principal employer is paying on the behalf of the employees of immediate employer, that is the EPF contribution that we are talking about. That means the 12% of the contribution of the immediate employer, that is the contractor, and 12% of the contribution from the employee that have been hired through the contractor. The principal employer can deduct it or recover that money from the amount that is payable to the contractor. This is a well-settled law, you can say well-settled principle. If a principal employer is engaging in employees through a contractor, and the EPF contribution that a principal employer is paying, EPF contribution, that means the 24% that he is paying on behalf of the contractor, that is 12% the employer contribution, 12% the employee contribution on the behalf of the, you can say, on behalf of the immediate employer, that is the contractor, that can be recovered from the amount that is due, or you can say that it is payable. He can deduct that amount, the amount which is payable to the contractor for his contract services. Now coming to the next, you can say, topic of EPF, the assessment part of EPF. There is one section in EPF Act which empowers the EPF department to determine the contribution that is due from the employer. That is section 7. And it is the most, you can say, harsh. It is the most, you can say, a section which causes a lot of panic across the entire business community if it receives a notice of proceedings under 7A from the EPF department. Like I said, if the EPF department thinks so that there is a underpayment or there is an amount which is due from the particular establishment and it has not paid that amount, or there is a dispute regarding the date of applicability of the EPF Act on a particular establishment, then EPF department can issue a notice under section 7A and it can start the proceedings under section 7A of the EPF Act for determining whether the EPF amount has really escaped, or there is a salary which has escaped the payment of contribution, or the date of coverage needs to be decided, then what the actual date from which the company has got itself enrolled under EPF Act and making payment henceforth. Now, it is a very, you can say, like I said, very harsh provision it has contained. Section 7A is you can say, quasi-judicial inquiry. The proceedings are as good as a quasi-judicial inquiry in this case. When this section was used very widely by the EPF, you can say, regional offices and the district offices across the board or across India, EPF came out with a circular to bring the uniformity in the procedure for initiation of section 7A, how this has to be followed and how this has to be used for the recovery of dues or for determination of dues in the case of any establishment. The first thing which was brought to light was, in EPF Act, there is no time bar limit. What I want to say is, if you have a EPF amount due, or you can say, if there was a company which has not paid an EPF Act which was due 10 years ago, or you can say 15 years ago, let's say for example 2005, almost 20 years ago. When we talk about any other, let's say for example, Revenue Act, if you talk about income tax or GST, then we all know if there's any income which has escaped assessment, which income which was earned in you can say 2000 or 2005, then we can squarely say now income tax department does not have any provision, or GST department or in that department does not have provision to recover that amount, or you can say tax that particular income of me. Even it has gone without, the income tax was not paid on that particular income. That is not the case with the EPF Act. EPF Act can go beyond any time to decide or to determine your dues. Even if I say 15 years, 20 years, 25 years, there is no back time limit for the EPF Act. Now, in this particular situation, what it said, the circular said, was released in February 2020. It said that only if there are material evidences which are available, which shows that the amount which has escaped assessment goes beyond 5 years, then the period of inquiry should be restricted to 5 years only. That means they have, you can say, through the circular, have decided that the EPF department, or you can say the various regional officers, should not try to honor the amounts which are beyond 5 years. This can only be done, the period of 5 years can only be go back to even longer, even only in the case when there are concrete evidence, or you can say, which shows that the EPF establishment or any establishment has skipped the assessment, or it has not paid EPF dues on a particular amount. Otherwise, the period of inquiry has to be restricted till 5 years and cannot go beyond this. Next thing which it said, now one of the things happen is when an employee leaves any establishment, then, and if he does not leave on a good note with the employer or the company, sometimes it may happen that a complaint is lodged by that particular employee against the company in the EPF Act to find out the irregularities in the payment of EPF. What this circular said was that a mere complaint itself will not constitute any prima facie evidence which is sufficient to initiate inquiry under Section 7. That means there has to be a legal proof which needs to be produced before the authority before starting an inquiry under Section 7. A mere complaint would not constitute, even because what was happening was even if a mere complaint was lodged by any particular employee, then the Section 7 inquiries were conducted by the field office. That has now been taken care of. That only if there is a case of a prima facie evidence which shows that EPF amount has not been paid, or you can say the EPF due has not been deposited by the company in case of the employee, the inquiry of Section 7A can be started, and not merely on the basis of a complaint which has been lodged. Now, also there was a thing there before, you can say, initiating any inquiry, a satisfaction note has to be signed. This has to be done by the enforcement officer, has to make an inquiry before even initiating 7A. Inspection has to be conducted, and a show cause needs to be given to the establishment. And on the basis of this inspection and this show cause notice procedure, if the department is satisfied, yes, there is, that means there is a reasonable, you can say, reason to believe. There is a reason to believe that yes, there is a chance, there is a, you can say, evidences which shows that the EPF contribution has not been paid by a particular company. So therefore, Section 7 inquiry has to be initiated against it. Then only the Section 7 inquiry can be initiated. Otherwise, the Section 7 inquiry cannot be initiated. And also, the Section 7 inquiry has to be conducted in the terms of the procedure that has been laid down in the Act. Sometimes merely because of the procedural lapse, the inquiry gets, you can say, quashed by the Honorable High Courts in the various cases. Now, one thing that I would like to point out here is, obviously, the new Wage Act has not been implemented yet. It may get implemented in, you can say, few months' time. The new wage code, it also contains the EPF Act. In that wage code, the period of 5 years has been incorporated in the Act only. And it has said the EPF inquiry cannot go beyond more than 5 years, or you cannot ask for records beyond 5 years for determining the dues from any establishment. This has been incorporated in the new Act only, although it has not been implemented yet. Also, what the new Act has said is, it has given, earlier there was no, apart from this Honorable Supreme Court ruling in the case of Vidya Mandir, there was no Act which defined how much can be the, you can say, what can be the salary structure of any establishment, means how much percentage will be assigned to any particular component. That means at present, if there is a company which says that we pay 30 out of the total 100% of the, you can say, wages, 30% is of basic wages, rest 70% is of the, you can say, allowances. There is no at which you can say entails that this cannot happen. This definitely can be done. If this 70% is shown, this is the nature of a special allowances. But the new, you can say, wage code or labor codes have incorporated, or it has said, you can say very clearly in the new wage code, that basic wages plus DA on which the EPF contribution has to be paid cannot be less than 50% of the total wages. So it clearly means there is going to be at least 50% amount of the basic wages on which the EPF has to be paid, although the statutory limit of 15,000 still has been carried forward in that particular, in the new wage code also. But this was the thing in the new wage code which has not been implemented yet. Now, there is one or two important case laws related to EPF, which I would like to discuss over here. The first one is in the case of HP State Forest Corporation versus Regional Provident Fund Commissioner, in which the Honorable Supreme Court has said the amount which is due from the employer, that means the EPF contribution that is due from the employer, can only be determined in respect of those employees which are identifiable and whose entitlement can be proved on evidence. And in the event the record is not available with the employee, it would not be obliged to explain its loss or any adverse interference of this course. So this is a decision which is in the favor of the, you can say, business community. And also there are various high courts which are of the same opinion. What the crux of the matter is, sometimes when the inquiry happens, in the case of a particular establishment, then there are few employees which are hired on temporary basis whose wages are paid and which leave the organization, which only work for 1 month, 2 months, 3 months, like that. And the inquiry initiated, let's say, for example, after 6 years, and you are not able to decide, and the EPF department comes that the contribution needs to be paid in case of those employees. But the situation is, if we come down to the core of this EPF Act, it is a Social Security Act. So if the contribution has to be paid, then it has to be paid in respect of an employee, and it goes to the ultimate beneficiary. So if we are not able to identify who is the ultimate beneficiary, then whom we have to deposit that amount, in respect of whom we have to deposit an amount. To the same effect, the division bench of Patna High Court in the case of RPFC versus Nandalan Company said that the assessment under Section 7 of the EPF Act should not be confused with an assessment with the tax. The assessment of tax, that is the income tax and indirect tax, is a different thing. And the assessment of dues under EPF is a completely separate thing. And it should not be confused with it. These are the provident fund dues that accrue to the individual and that are not a tax, and which are not payable to any, you can say, provident fund commissioner or any provident department. So unless the names of employees are identified with certainty, the assessment cannot be said to be done in accordance with the law. So this is a very welcome, you can say, decisions which act as a safeguard for the employees in such situations. Now, coming to the next point, like I just discussed earlier, that when we talk about any employment or when you talk about any company, not only the employees of that particular company are called as the employee of that for the purpose of EPF, but also the contracted employees or employees hired through a contractor also become a part of your employee strength. This is true. But what about the situations where the contractor itself is having an independent EPF registration? Because it may quite happen the contractor may be providing its, you can say, services to 5 different organizations, and the total employee strength that he may be having under him may cross out 20 itself. So in this case, there has been obviously numerous cases which have set out this rule, which said that contractors which are having a separate EPF code are independent employers, and the establishment that we are talking about, the principal employer, you cannot consider that establishment as a principal employer for such contractors. What it actually means is now that if a company is hiring any contractor to provide its service, or it is hiring employees through our contractors, and that particular contractor is having a PF code of its own, then in that particular case, the principal employer or the company which is hiring is not required to make any compliances in respect of the employees that have been hired to the contractor. It becomes the responsibility of the contractor who's having a separate code and who has provided labors to particular company to make the contribution, to pay the contribution, and make the all the compliances in respect of those employees. And even if the authorities seek any details from the establishment which has hired the employees through the contractor who is having independent code, they only have to give the name of the payment of contribution of the areas which is payable by the contractor. That means the duty is only limited of providing the list of the contractor to the relevant authorities with their EPF code. But they cannot be said to make the compliances. And if the main contractor having the independent code has not made the compliances, then the amount, so you can say, which is payable in respect of the employees hired through such contractor, is recoverable from the establishment which has hired those employees. Now, one of the very important, you can say, decision which has been given by the Honorable Supreme Court. One of the basic things that we have studied in the company law is that the company is a separate legal entity. This is a well-established fact in the company's law. But a welfare legislation, just like this EPF Act, does not, you can say, it takes a backseat while ensuring that individual right or the EPF right of an employee is protected or not. In one of the cases of Shri Vishal Printers Limited, what the Supreme Court said, what happened was there was 3 companies. One was BCCL, one was THPL, and one was SPL. The TPHL had an agreement with BCCL to publish the Jaipur edition of the daily newspaper of BCCL. For this, THPL, what it is, it opened an office with all the infrastructure, administration, secretarial staff, training manpower, and all those things in the space which was provided from the side of BCCL, that is in the premises of BCCL. Also, the third company, that is the Shri Vishal Printers Limited, it entered into agreement with BCCL to publish the Jaipur edition of the T newspaper on a contract basis. Even though the printing press was elsewhere, the business office of the Shri Vishal Printer Limited was in the same building as of BCCL and THPL. Now, the case decided was that whether for the purpose of EPF, these three companies should be considered as three separate entities or should be considered as a part of, or you can say a branch or unit of a single establishment. See, if we say about a company, then obviously there are three separate companies which are being established and they all have a separate entity in the eyes of the law. This is thing. But what the Honorable Supreme Court said was to decide whether different establishments are a part of a single unit or three units are a part of a single establishment. The most important test is the functional integrity. So, even if there are three companies, but they are working for a common objective, they are working together for a common objective, and in this case, it was to bring out the newspaper. And Supreme Court relied upon the test of functional integrity and said you cannot call these as three separate companies. You can only call it as a part of a single establishment. So the employee strength has to be taken to decide whether EPF Act is applicable or not on the basis of the employee strength of these three companies in aggregate. So this is a very important judgment, which you can say takes a divergent view from the separate legal entity concept that we all know. Now, this was the deliberation in the case of EPF. Now, moving on to the topic of ESIC. The provisions under ESIC are more or less similar than what it is in the EPF Act, but starting with these compliances which are under the ESIC Act. Aman, shall we take question and answer at the last, or we can take now? Or,
As you say so.
I guess it will be better if I'll just complete with the ESIC Act and after that we can take up the question answers.
Yeah, sure. We'll take 5 best questions.
Okay, thank you. Now coming to the ESIC Act. Just like in EPF Act, the employee strength was 20. In the case of ESIC Act, the employee strength is 10. That means if there is any establishment which is employing 10 or more employees on any given day in a year, then that particular establishment has to get itself registered under the ESIC Act. In EPF Act, we have studied there is a concept of voluntary coverage, that is section 1(4) of the EPF Act. It provides a facility to the employee, or you can say to the employer, that it can get voluntarily enrolled under the EPF Act. But that is not the situation in the ESIC Act. There is no concept of a voluntary coverage under the ESIC Act. That means only and only if the employee strength reaches the threshold limit of 10 employees, then only the ESIC Act will become operative in the case of that establishment. Otherwise, ESIC Act will not become operative in that particular case of in that particular establishment. And again, once an act becomes applicable in the case of ESIC, that means once you reach the threshold limit of 10 and subsequently the employee strength goes down below 10, then also the ESIC Act will continue to be applicable on that establishment. So let's say, for example, in April 25, the employee strength reached 12, ESIC will become operative, and subsequently in August, the employee strength fell down to, let's say, for example, 4 employees. Then also the employee ESIC compliances needs to be made in case of such establishment. The establishment has to provide ESIC benefit to the employees who are working over there. The thing is, who are to be counted for the purpose of count of 10 to decide whether ESIC Act will be operative or not. Then means all the employees that are hired over there, all their trainees, all the, again, the contracted employees, like it was in the case of the EPF, not only the direct employees of the company, but also the employees hired through the, you can say, the contractor, are to be taken for the purpose of coverage of any establishment in ESIC Act. Even the directors who are on salary are to be taken in, you can say, the employee strength of 10 to decide the applicability of ESIC Act. Next, who will not be a, you can say, employee to be taken into account of 10. If there is a partner who is drawing a salary, obviously you cannot take him as like that. A contractor who is lending the services of his employee will not be a part of the 10. An apprentice who is covered under the Apprentice Act 1961 will not be a part of this ESIC, or you can say a part of this 10 employees that is required for the coverage of any establishment under the ESIC Act. Now, one thing that I wanted to state, I was talking about the registration with an employee when the EPF Act becomes applicable, then obviously, or ESIC Act becomes applicable, then the establishment has to get itself registered under the EPF and ESIC Act. And the thing is, the procedure is on auto approval basis. That means if you file an application for the EPF registration or the ESIC registration, then it does not need to be approved by any authority. As soon as you file the application and the application is complete in all the respect, your EPF code and ESIC code will be generated, and there's no need to get it approved from any authority, or it will go to any authority for approval. As simple as that. But there is a special provision ESIC Act in the case of a labor or manpower supplying agencies. In the case of a labor and manpower supplying agencies, for them to get registered under the EPF Act, an advance contribution of 6 months has to be paid first before the registration is granted to them. This is only in the case of ESIC Act and only for the labor and manpower supplying agencies. That if any manpower and labor supplying agency, the employee strength crosses to 10, and it wants to get itself registered under the ESIC Act, and then after filling the form, it has to first of all make a payment of a 6 months advance contribution via the chalan, advance chalan, that is we call it as. Then only you will say that registration will be granted. So registration is a subjective in the case of ESIC for labor and manpower supplying agency. Otherwise, the registration is on a auto approval basis. Again, when we talk about the definition of employees under the ESIC Act, like I said earlier, every employee who is directly employed by the, you can say, you can say the company organization will come in the ambit of employee. Any person who is a contractor and who has engaged employees to an establishment, that will also be counted in the ambit of employee for the company for the purpose of counting 10. Now, coming to the topic, this was the case of means the definition of an employee is more or less similar in the case of EPF and ESIC Act. There is not much difference in case of all those employees. Obviously, there is a concept of, you can say, an exempted employee in case of an ESIC. Exempted employee means if the average daily wages of any employee is rupees 176 or below. This is the current limit of 176 or below. It gets revised. You can see before it was 137, now it is 176. 176 or below. Then the employee contribution. Listen very carefully. It is the employee contribution that need not to be paid in respect of those employees. But the employer will continue to make his contribution in respect of those employees. When we talk about ESIC, it gives you can say advantage to the employees whose daily average wages is 176 or below. Then in respect of those employees, only the employee's contribution need not to be paid. The employer contributions still have to be paid in case of those employees. Now, coming to this contribution amount, how much contribution has to be paid in case of the ESIC Act? In case of EPF Act, just we have learned that it is 12% on the part of employer and 12% on the part of employee, and plus there are also 1% as a, you can say, administration charges on 1% as, you can say, uh, EDLI charges, combining both, that the contribution is paid by the EP, you can say paid in respect of the employees in case of EPF. That percentage is 0.4% in total, you can say. In case of ESIC, the total contribution is 4% of the wages earned by an employee in a particular month. This 4% is again split in two, you can say, parts. One is employer contribution and one is employee contribution. The employer contribution is 3.25 and employee contribution is 0.75. Earlier, it used to be 6.5% total. That was 1.75% the employee contribution and 4.75 was the employer contribution, but it was revised later on, and it has now been reduced to total 4% in all. Out of that, 0.75% is the employee contribution and 3.25% is the employer contribution. Now, the due date for payment of ESIC is identical to the due date of payment of EPF. That is, the contribution which is due in a particular wage period, it has to be paid by the 15th of the month following the wage period. That is, for the wage period of April, the ESIC contribution has to be paid by the 15th of May, for the May 15th of June, by the June 15th of July. There's also one thing in the ESIC, that if an employee is not able to deduct an amount of ESIC contribution of employee from his salary in a particular month, then he cannot deduct it at all. That means if the ESIC contribution of 0.75% was not deducted from the salary of ESIC from the employee, then you cannot club that amount and deduct it aggregate in the following month. Although the payment of 4% has to be made to the, you can say the contribution of 4% will be paid to the ESIC department, but the deduction cannot be made if you skip the deduction from the salary of the employee. Now the question arises, what is the wage ceiling limit under the ESIC Act? Like we studied in EPF Act, it was 15,000 per month. In ESIC Act, it is 20,000 rupees per month. The current limit is 21,000 per month. The drastic, you can say, difference here between the EPF and ESIC is that, like we said, that the contribution of 12% of EPF is paid on the basic wages plus dearness allowance plus retaining allowance. But in the case of ESIC, the 21,000 that we are talking about is the gross wages, and the contribution is also paid on the gross wages. That means if an employee is getting basic wages, is getting dearness allowance, if he is getting, let's say for example, HRA and any other allowance that he is getting, it will all be clubbed together, and the 4% will be calculated of the gross wages that an employee earned in a particular month. Coming back to the topic of the wage ceiling limit under ESIC, that is 21,000. If an employee is drawing a salary of rupees 21,000 or less, then he is eligible to get the benefit of ESIC. That means the contribution has to be paid in the respect of those employees. And if an employee is earning a wages of more than 21,000, then ESIC contribution need not to be paid in respect of those employees. Now, in EPF Act, we studied that if once a employee becomes a member of EPF, then even if his salary crosses the threshold limit of 15,000, he will continue to be the member of EPF Act. But that is not the scenario in the case of ESIC Act. That means if a member has become, or you can say an employee has become a member of ESIC, reason being his salary was less than 21,000. But once he crossed the salaries or his salary by the way of hike or increase crosses rupees 21,000, then he will discontinue to be the member of ESIC. That will not get the benefit of ESIC. Now, how does it operate? Before telling how this operates, let me tell you one thing. The ESIC Act, what it does is, it divides a financial year into two parts. That is two contribution parts, contribution period that you see. First one is from April to September, and next one is from October to March. The financial year is divided into two contribution period, April to September and October to March. Now, if the salary of any or the wages of any employee increases during any contribution period, let's say for example, if Mr. A was getting a salary of 18,000 in April 2025, and he is working in establishment which is enrolled under ESIC, and ESIC contribution is payable and paid in respect of those employee in April. And subsequently, in the month of May, the company increased his salary to 22,000. That means beyond the statutory limit of 21,000, which is prescribed under the ESIC Act. In that situation, since the salary has been increased during or in the mid of any contribution period, that is from the April to September, then till the end of this contribution period, that is September 2025, that is the wage month 2025, contribution will be paid in respect of that employee. He will only go out of the coverage of ESIC following in the next contribution period, that is from the October 25 onwards. So one thing is clear, that if the salary of any employee, it crosses the statutory limit of 21,000, then he will, contribution need not to be paid in respect of that employee, because he will not get the benefit of ESIC provisions. But the contribution will stop after the end of the contribution period in which the salary has increased. Let's say, for example, Mr. A was earning a salary of 18,000 till March 2025, and the salary of Mr. A increased from April 2025, and it increased to 22,000. So it has increased in the beginning of the financial, you can say, contribution period as per EPF Act. So from April onwards, the contribution need not to be paid in the case of Mr. A, because it is started in the beginning of the, or before the, you can say, start of the contribution period. Is it clear? Now, coming on to the topic is whether any company or a factory establishment can get an exemption from coverage or registration under the ESIC Act. Yes, there is a provision, section 87 of the ESIC Act says that if the employees of any company or a factory or establishment are otherwise in receipt of benefits which are substantially similar or superior to those provided under the ESIC Act, then an application need to be made to the state government, and the state government may grant exemption to such establishment for a period of 1 year only. Remember this. At a time. That means at a time only exemption of 1 year will be given. And if we want to continue this exemption, let's say for example, if a company applied for exemption from ESIC Act, reason being it was providing the benefits which are given to the employees under ESIC Act, or the benefit that is providing to the employees, its employees, are substantially higher or superior or equal to what is been provided to employees under EPF ESIC Act, then that company can apply for the exemption from coverage under ESIC Act. But the exemption will only be granted for 1 year at a time, and for application for the renewal of exemption has to be made before the expiry of 3 years from the exemption or even the expiry of 3 months, of exemption period, before the expiry of 3 months from the expiry of exemption period. Now, like I said, the definition of wages under ESI Act means, because we are studying here, the 4% of wages has to be paid. What is the wages? Like I said, the term wages is of wide import in ESIC. It means all the remuneration which is paid to an employee in terms of his contract of employment, whether it may be his HRA allowance or any other allowance or basic NDI, everything will be covered. Although any contribution of EPF which is paid by the employer on behalf of employee will not be covered. The traveling allowance will not be covered, and any expenses or sum which is paid to defray any special expenses, that means to make up any special expenses, will not be covered, and any gratuity which is payable to the employee will not be covered in the definition of wages under the ESIC Act. Otherwise, every other component of salary will be covered under the ESIC Act, and ESIC need to be paid in respect of those things. One important thing here, it is, if there is any additional remuneration which is paid to any employee, which may be in the form of incentive, which may be in the form of a bonus, in the form of a commission, and if it is paid at an interval of more than 2 months, then such additional remuneration will not form part of the wages under the ESIC Act. That means contribution need not to be paid on that additional remuneration. But if any remuneration, additional remuneration is paid in an interval which does not exceed 2 months, that means if the commission is paid or the bonus is paid on a monthly basis, then it will form part of the wages, and ESIC need to be paid on that particular wages. Now, quickly, I will just tell you some of the allowances which either are included or excluded from the definition of wages. Washing allowance, it is excluded simply because it is said it is a sum which is paid to defray special expenses. The suspension or subsistence allowance, which is paid to an employee when he's not actually working, but just to get him in touch, or you can say attached to the service of the employer, it is included in the definition. Annual bonus, it is excluded. Reason being, the term itself, it is annual bonus, and annual bonus is paid an interval of more than 2 months. It will not be included. House rent allowance, it will be included in the definition of wages, and ESIC contribution has to be paid. Night shift allowance, heat allowance, gas allowance, it will all be included, and ESIC contribution has to be paid. Recently, in the case of, you can say, in the case of ESIC versus Techno Industries, Honorable Supreme Court said conveyance allowance will not be a part of your wages, and ESIC contribution need not to be paid, because it is a kind of a traveling allowance only. So you can say conveyance allowance will not be a part of salary, and ESIC allowance not to be paid on. Medical allowance, yes, included. Newspaper allowance included. Education allowance included. When I say the term included, it means it will be part of wages, and ESIC contribution will be paid on it. Talking about the hotel industry, there is a service charge which is collected by the management on the behalf of, you can say, the employees. Instead of direct tips, you can say there are many hotels which do not allow to give tip to their you can say waiters or the persons over employees over there, but they add service charges in their bill and they distribute it among those employees. The question arises that will this service charge will constitute wages? The answer was no, and the same was also decided by the Honorable High Court of Jaipur, held it in the case of ESIC versus Rambagh Palace Hotel, that service charges are not wages under ESIC Act, and this has also been accepted by the ESIC department, and no contribution is payable on such service charges. Now, the thing is whether any short-term contract which for service which is engaged, like electrician, carpenter, mechanics, whether ESIC contribution is payable in respect of those short-term contract? ESIC said yes. If the services are rendered within the premises, ESIC contribution has to be paid in respect of those short-term contracts. And the same view was also, you can say, held by Honorable Punjab and Haryana High Court, which said that short-term contract employees which are there, ESIC contribution becomes payable in respect of those employees. Luckily, payment made to consultants, lawyer, chartered accountants, engineers, they do not fall within the definition of you can say wages, and no contribution is payable in respect of them. Like I was saying, coming to the topic of contribution, like I said, the total contribution paid is 4%, 0.75% is the employee share, 3.25% is the employer share. Due month is always 15th of the following month. Wage saving limit 21,000 that we have discussed, and the delay for payment. If there is a delay in the payment, the interest and the damages rate in the ESIC is similar to that in EPF. That is, interest will be paid at 12% per annum, simple interest for the period of delay. And for damages again, 2 to 4 months, 5%. 0 to 2 months, it is 5%. 2 to 4 months, it is 10%. 4 to 6 months, it is 15%. Above 6 months, it is 25%. And restricted up to the amount of contribution. It cannot go beyond that. Now, one of the topic that I want to bring to your kind attention here is from 15th February 2020. The government has made, or you can say, made a rule that in case of every newly incorporated company, EPF and ESIC registration number will be assigned to them during the process of incorporation itself, irrespective of the fact whether they are eligible for the same in terms of the employee strength or not. That means if any company gets incorporated after 15th February 2020, then the EPF code and ESIC code will be assigned to them at the time of company incorporation only. But central government, it issued a press release and said that the companies who have been assigned EPF and ESIC code at the time of registration only are not required to file the EPF returns or comply with the EPF provisions and ESIC provisions unless and until they reach the threshold limit of 10 employees in the case of ESIC and 20 employees in the case of EPF. And once they reach the threshold limit, they have to comply with the provisions of EPF and ESIC Act, not before that. Although the code has been allotted to them, but still they did not to make the contribution or did not to make file monthly returns in respect of their employees. Now, what ESIC has done, it has introduced, you can say, white circular. It is introduced a facility for such companies which have been mandatorily enrolled which have been incorporated after 15 to 2020 and mandatorily enrolled under ESIC Act, but are not having the employee strength of 10 employees. It has come with a circular in 2022, and it says that for all the newly registered companies which have been registered on after 15 to 2020, they have to comply only when the threshold limit is crossed. But what they need to do is they need to mark their status as dormant. That in ESIC portal, what they need to do is that they need to mark their registration status of ESIC as dormant for a 6-month period. And after the expiry of 6 months, even if after the expiry of 6 months, they do not cross the threshold limit of 10 employees, again, they have to mark their status as 6 months. And for every 6 months, they need to continue their dormant status or extend their dormant status if they do not cross the threshold limit of 10 employees. And once they cross the threshold limit of 10 employees, then they have to continue, or they will have to make the compliances in respect of the employees and pay their contribution. And for every 6 months till they reach this limit, they have to continue marking their status as dormant in the ESIC portal. With this, I conclude my deliberation today. I would like to thank the entire committee, especially Abhay sir, and all the members associated with the committee, moderator for today, Aman, for
Thank you, sir.
giving this opportunity to me to express my views on the labor law. And I hope that the listeners of this webinar would have benefited from this. And if there's any query to them, we can take up now. Aman, if there is any
There
query.
are many questions, but I would like to take just 5 questions because there are some time constraints.
Aman, can you speak a little louder? I'm not able to get what you're saying.
So there are many questions,
Yes.
but I would like to take just 5 questions because of time
Yes, yes, please.
constraints. So first one is, CAM changes, can CAM charges paid to faculty management companies or IT parks be brought under the ambit of ESI, especially when no direct employee-employer relationship exists? This is the question.
Can you repeat it once again? I'm not able to get what the question is. Aman, can
Can
you repeat the
CAM
question, please?
changes? Hello, am I audible?
Yes, audible. Please repeat the question once again.
Can CAM charges
Uh,
paid to faculty management companies
hmm.
or IT parks be
Hmm.
brought under the ambit of ESI, especially when no direct employer-employee relationship exists? This is the question.
No, see, for the making any charges applicable, like I said, there's a drastic difference between the contract of service and contract for service. If this is a contract for service, then definitely ESIC and EPF obviously will not become payable in this case. If it is a contract of service that has to be a, you can say, master servant relationship in this case. I would like to quote one of the cases in this particular case, which obviously has some divergent view, or we can say, which was in the case of Godavari Garments versus the Assistant Provident Fund Commissioner. In this case, what was happening was Godavari Garment was a company. It was in the, you can say, business of manufacturing ready-made garments. And what it did was it engaged and to provide meaningful, you can say, gainful employment to women who are from the economically weaker section of the society for stitching and tailoring. Those women used to work from their home with their own sewing machine and provided to them with the raw materials. They were provided the raw material, and the sewing machine and the stitching was done by them in their home itself. Now, after completing those ready-made garments, they supplied the material back to the company. What the High Court ordered in this case was there exists a case of a employer-employee or a master, you can say, servant relationship in this case, because the company had the right to reject the goods, that it exercised, you can say, control over those employees. It provided a design, it provided everything. So there exists an employer-employee relationship. So here, although those women are working from their home or not coming to the factory, are using their own sewing machine and tailoring machine, but still they would be called a part of the employee of, or you can say, they will be called as the employee of the company. Now, if it is now in the coming to this particular question, if it is a case of contract for service, that means the company to whom the services are being exercises a reasonable amount of control over those employees, then there may be a case that it becomes that ESIC and EPF will be payable in respect of those cases. Next question, Aman.
Okay, sir. Next question is, if a company with less than 20 employees voluntarily opts for EPF registration,
Hmm.
can it later exit the scheme if headcount remains below threshold for a prolonged period?
See, there are various High Court judgments which allow it to do so. Because EPF Act was never became applicable to them via the mandatory thing. It was only by notification in the official gazette that the EPF Act became applicable to those companies. So if this notification can be withdrawn, and numerous high courts have held of the opinion that this can be done, that the notification can be withdrawn and the companies can get out of the scheme of the EPF Act if it is a voluntary coverage.
Okay, sir.
Hmm.
Third question is, what are the legal implications for employers who default in timely PF deposits, specifically in terms of penal interest, prosecution, and employees' interest loss?
Like I said,
Employees' interest. Right.
I guess there are three questions. One is asking for the financial loss, that is the interest and penalty that the question asks, and the prosecution, that is what is intended. See, what I'm saying is, it is since the EPF Act is a legislation which is made primarily with the objective of benefiting or to safeguard the interest of the employees, then if there is a delay in payment of the contribution of employee, then there is a provision of interest, like I said, of 12% per annum that needs to be paid. Penalty, depending upon what is the length of default, that has to be paid. The situation becomes very draconian if the EPF is deducted or not paid. Then it becomes a case of a breach of a trust, and the situation may amount to fraud. And then a prosecution can be launched against that particular defaulting, you can say, employer. So if we are not deducting EPF, so let's say, for example, if a company was not knowingly deducting, if the company was unaware of the fact that need to deduct EPF, then only there is a case of financial, you can say, loss. But if you are deducting EPF and not paying, then it becomes a very draconian provision and becomes a case of breach of a trust. And there, all the criminal law will also get involved in.
Okay, sir.
Next.
Now, next question is, how should EPF contributions be handled when an individual earns split salary from Indian and foreign entities, especially in cross-border employment structures?
If he's earning salary from Indian and you can say
Indian and foreign entities.
foreign entities. No, in this case,
Like someone is working in India and even for working for some US firm. So what's that
no,
case?
if he's earning salary in India only, if he is getting a salary in India, for that the contribution, if he's salary getting a salary, if he's, let's say for example, if he goes on a special work for on behalf of the company to a foreign country for performance of his duties, and if the salary is earned by him in India and also in the, yes, in that case the contribution has to be paid for his entire salary.
Yeah,
You cannot say,
participant is willing to ask about employment structures, cross-border employment structures.
can you can you repeat it once again? What is it? Employment?
Yeah, sorry about that. I was saying, especially in cross-border employment structures.
Cross-border
Participant
employment.
is.
No, in cross-border employment structure also, there is a, you can say, the EPF contribution has to be paid. You cannot define this one thing for the salary that is earned in India and also for the salary that is earned even in the other foreign lands, which has been paid by the Indian companies. There is a question: the companies salaries included in Indian company only, na?
It's not specified by the participant.
I'm assuming it is paid only because if it is salary is paid by the foreign company, then
Because here written individual earns split salary from Indian and foreign entities.
split salary from
From Indian and foreign entities.
foreign entity. But if the foreign entity is registered in the EPF Act, if it is having any branch over here and it is earning salary from here, then for the period of length which is serving in India, he has to pay the EPF in that case.
And so last question is there any formal mechanism for closing or deactivating EPF registration of company whose operations have significantly downsized? And nowadays, as we know that there is some agile pro form, automatically we get ESI and PF registration. In that case, what will be?
And what I'm
So
saying
my
is,
personal question.
okay. See, when we talk about forward the closure of the EPF and ESIC registration, uh, see, once you get yourself registered in the EPF ESIC, it can only be closed when the company as such comes to the close or the unit or establishment comes to the close. That means these are going to be the last licenses or the registration which will be surrendered.
Okay.
Otherwise, still the company is in operation. The company is, you can say, existing. This registration cannot be surrendered. There may be one thing where you can say, if the company has not having any function at all, the company is not functioning at all, then also the EPF number and ECIC number can be surrendered. For that, an application needs to be made to the concerned office. They will mark an inspection. The application will be forwarded to the Delhi head office of the concerned EPF and ECIC. They will mark an inspection to that, and after the inspection is marked, the inspection will be conducted, and if they find that there is a chance that the company is not functioning at all or the establishment not functioning at all, then only the EPF and SIC number can be set. Otherwise, it is a difficult task to get itself, we can say, out of the purview of EPs, unless and until you close the establishment altogether. Otherwise, it will be difficult to get it surrendered.
Okay, sir. So shall we end the session?
Yeah, I guess so.
As we draw this session to the close, I express my heartfelt gratitude to CA Avinash Roteja sir for his well-structured presentation and practical insights on compliance matters under EPF and ESI. We all thank our chairman, CA Abhay Chachad sir, and vice chairman sir, CA Pramod Jain, for their leadership and constant encouragement for these type of incentives. A special thank you to all the participants for your presence and attention. There were total around 220 participants with us, and I thank them for their engagement and continued support to the committee. Thank you. Yes, we can end.